Danya Williams, a former federal prosecutor who served as senior investigative counsel for the January 6th committee. Danya Perry is the former chief of the criminal division for the Southern District, New York, served as deputy New York State Attorney General, and they both join me now. Danya, let me start with you on the. They have used these examples before, and the Trump breach is very. Frustrated or angry about it. They say that the brief ignores the actual lessons from history and provides a list of lurid hypotheticals that have never happened, including treason and murder. What is the point that Smith is making here?
I think it emphasizes how broad Trump's argument is, and that's what he wants the court to understand. If the court is to go with Trump here, what that means is that not only does the president have immunity, but the president can engage in this kind of wide-ranging, conduct here. And the president, whether it be President Biden or any future president, would have no, the American people would have no recourse against punishing that president. So I think while these are perhaps somewhat extreme examples, we should remember we are dealing, in fact, in reality, with an insurrection. So it's not that extreme. You have a president who led a violent mob to attack the Capitol. The idea that that same conduct or that kind of president could also sell nuclear secrets or otherwise engage in violence, we've seen a president effectively engage in violence against the U.S. So I think they're appropriate examples, and I think the court will take notice of it.
Well, it was funny to me, Danya, to see that in reply, Trump's lawyer is saying that it was that these are things that have never happened. It's like, well, yeah, January 6th it never happened until it happened. Yeah. Everything here is out past the frontier of the known.
Right. I mean, a lot of their argument is there's no precedent for you're not going to find anywhere in the law books any precedent for the use of presidential immunity. Well, of course not, right? It's never happened before. So they go back to Marbury versus Madison in 1803 Supreme Court case. They pick out little snippets, from the Federalist Papers. There is nothing, simply because no one's ever done anything like this before. So there's an absence of case law and precedent for this. But the fact is, the former president is subject to the same laws as everybody else. They say nothing new in these Court of Appeals papers. There's nothing new to be said. And I'm quite certain that when this goes to the Supreme Court, if this goes to the Supreme Court, they're not going to have anything new to say either.
Well, we're going to get oral arguments in this case next week in front of that three-judge panel. I mean, it strikes me, too, that the sort of argument specifically that Trump's lawyers are making is that this is at the outer perimeter of his official duties, right? So that there's this, if there's any interface at all with a thing that could plausibly be called your official duties, in this case, protecting the election integrity of the U.S., then you're immune, right? And so Smith, in these examples, is saying, okay, these are things that you would be in the catchment area of things that you're saying are immune if we took seriously your argument.
Exactly. And what Smith does well is that he points out how Trump's legal team is basically zooming out. And if you zoom out from any legal conduct, it sounds pretty normal. So you may be contacting state officials and trying to help, get them to conspire with you to overturn an election. But if you zoom out, it's just a president talking to state officials.
I'm just talking to someone. Yes, exactly. This has been the consistent defense.
Exactly. And what Smith asked the court to do is that, no, look at what we're actually talking about. Look at the facts. So whether it be selling nuclear secrets, whether it be conspiring to overturn an election, look at the actual facts and then understand whether, if you were to grant immunity, what does that mean for those facts?
So I want to just talk about that American oversight brief I mentioned in the previous block, which is an amicus. And the only reason I think this has gotten people's attention is the order in which the judges say, hey, come ready to talk about some stuff that might be in the amicus. So here's the argument from that brief. The court should dismiss this appeal for lack of jurisdiction. Under controlling Supreme Court precedent, an interlocutory order, which is what they're seeking, right, denying immunity in a criminal case is not immediately appealable unless the claimed immunity rests upon an explicit statutory or constitutional guarantee that the trial will not occur. What did you think of the argument?
It looks strong. There are very few such immunity guarantees. We know of two, I believe, the speech or debate clause and double jeopardy. Those are two that are enumerated. There are others that courts have said do not exist. So other types of immunity that have been shot down by the courts. Presidential immunity, of course, has never been tested in the courts.
Right. So he's saying because these aren't in the category that are already established by the Constitution or explicitly granted, you don't get this thing called an interlocutory appeal. Usually, right, the way this all works is, and you'll see this after people get convicted, they come outside in the steps and the lawyer says, we're going to appeal the conviction. Right, because almost everything that you would appeal, you got to go through the process first.
Exactly.
You could then go and say, actually, that search warrant was, unconstitutionally granted, and all of that evidence has to be thrown out, and there's a mistrial or something like that, right? But normally, you don't get to do it ahead of time. This is a special category, and that appeal brief, that brief is saying, no, it doesn't really apply here.
Right. So it could be a really interesting twist here. It could be oral argument or next Tuesday, I believe, the 9th. So the court, of course, has asked the lawyers to focus on it. We haven't seen the counter argument to it yet. So, of course, Trump's lawyers will focus on it at oral argument. We'll hear what they have to say. The circuit court judges will push back.
Yeah.
I'm sure there'll be lively debate and discussion. And who knows? Maybe they will issue an order on this ground, and that could be the end of it.
That would basically been saying, sorry, you can't actually do this appeal now. We're not actually deciding on whether this. We don't have jurisdiction. What are you looking for in the sort of arguments next week?
Well, if it's a hot bench, which means a bench that's asking a lot of questions, which I expect it will be, it's to get insight into the panel. What are they focused on? What questions are they asking? What are they really pushing the lawyers on? That's the best way we can kind of look through the leaves to see what the thoughts are. And I also suspect we're going to get a quick opinion.
Yeah.
I mean, this may not seem fast to folks watching at home, but for the lawyers, this is moving at lightning speed. So I suspect these judges already have a sense of where they're going on this.
Yes.
And I suspect they're already drafting an opinion as is, and we'll get that pretty quickly.
Danya, Williams, Danya Perry, thank you both.